This is LXBN TV, and I'm Colin O'Keefe. The National Labor Relations Board recently released its third report on social media. To explain the report and what it means for employers, we bring in Mark Theodore, partner in Proskauer's Labor and Employment Law Department and author on their blog, Labor Relations Update. Mark, let's start with the background of the report. I understand that this is the third iteration. How has this progressed over time, and what do we have in this one?
Colin, the report progressions have been pretty basic. The first two have dealt with employer actions taken against employees, and so they've dealt with discipline that employers have taken against employees for things that they've done on social media. Those are the first two reports. The third details exclusively employer policies and how they relate to the National Labor Relations Act.
I know that's a topic that many people are interested in, their specific social media policies and whether or not they're lawful or not lawful. But, just as the report did, let's start with the elements of social media policies that are considered to be unlawful. What did the NLRB lay out as being unlawful, and were any of these surprising to you?
Yeah, that's a good question. I always tell clients and people who ask this that almost every policy that we look at has some problem that under the National Labor Relations Act, or at least that the NLRB would consider to be a problem. And they fall into three categories. The first is confidentiality policies, policies that prohibit what you can say outside the workplace and to other employees, and the government consider those to be too broad, generally because an employee might want to talk about his wages, and they might interpret that policy as prohibiting that. The second has to do with who you can do, and those are the press-related policies. It says, you may not speak to the press, you can't talk to a reporter, and of course those are considered too broad because as very often is the case, an employee can talk to a reporter about a workplace issue and it wouldn't be a violation of the act. Really what the employers usually mean is don't talk on behalf of the company, is saying I'm a representative of the company, and etc. And then the third has to do with the types of things that you can post. And the language that employers use has been used in the workplace forever. Things that you can't do are things like abusive comments, inappropriate comments. However, the NLRB has taken the position those are too broad because they could inhibit employees talking about workplace grievances, for instance.
Yeah, I mean, go ahead, I'm sorry.
Those are the three main, I think, areas, and then there are various examples that the board has found to be unlawful.
There's so many things that I think employers think wouldn't be considered unlawful, but the NLRB says, oh, well, in this certain circumstance, you might be in violation of the National Labor Relations Act. So it's interesting to watch. And then finally, I think this is part of the report that many people found to be, at least part of it that was somewhat interesting and somewhat helpful, is that they posted a full report on what was lawful. So what can employers learn from the policy that the NLRB deemed to be lawful? What types of elements are fine by the NLRB?
That's a great question, and those are the questions that we've been trying to answer over the last several months. I think first of all, this is the first time that I'm aware of that the National Labor Relations Board has ever issued a full vetting of a policy saying here's something that's lawful. So it's helpful in that regard. The second thing that employers really can learn from it is that the language used in that policy is very carefully drawn to be narrow, to get at a specific problem. So, for instance, if it's the confidential information we were talking about, it prohibits only the disclosure of something that would clearly be prohibited, like trade secrets or proprietary information. It's very, and the language used, this is the second issue, is very simple and plain compared to what I think the board considers a problem in these policies, is that they're very technical and use bigger words. And the thing which I think is very instructive is that it uses examples of what would be considered unlawful, or prohibited by the policy. So there's no guesswork by the employee. And those are the types of things that are helpful. Whether employers adopt that policy or not is probably remains to be seen, but it is instructive to help you draw your own policies.
Yeah, I think a lot of times before this, people were left to say, if all these things aren't fine, what is fine? I think people were left out in the dark, and now you might see some people even just use the policy that the NLRB laid out. So it'll be interesting to watch going forward. Once again, that was Mark Theodore of Proskauer. For more on the NLRB social media report, be sure to visit his publication. It's at laborrelationsupdate.com, and of course lxbn.lexblog.com, where we have a wealth of insight on this subject from LXBN authors. Thanks for your time, Mark.
Thank you.